Vicky Pryce's recent trials for perverting the course of justice have raised a number of interesting legal issues. The one that I wish to concentrate on today is the defence of marital coercion, which Vicky Pryce relied on, ultimately unsuccessfully, at both of her trials. This defence is defined in section 47 of the Criminal Law Act 1925, which provides that on a charge against a wife for an offence other than treason or murder, it shall be a good defence to prove that the offence was committed in the presence of and under the coercion of the husband. I imagine many people will be surprised to learn that such a defence still exists in English law today. It certainly harks back to a time when wives were considered to be utterly incapable of disobeying their husbands, and that is why they would need a defence to crime. Obviously, that is an outmoded view of the law, and I want to argue today that the defence of marital coercion should be abolished. The main reason that marital coercion is so problematic is that it's so obviously discriminatory. Firstly, it relies on a very outmoded view of the marital relationship. I've mentioned already that only wives can use it. It seems ridiculous to assume in this day and age that husbands cannot also be subjected to coercion by their wives, and as I've already said, it's ridiculous to say that wives could be subjected to coercion by their husbands. Furthermore, it privileges marriage as a unique relationship. Since 2004, same-sex couples have of course been able to engage in civil partnerships. When civil partnerships were introduced, a range of legislation was changed so as to make clear that civil partners could make use of certain defences or could use certain rules. One example of this would be the rule in Section 80 of the Police and Criminal Evidence Act 1984, or PACE as it's more commonly known. Section 80 provides that a person is not generally compellable against their spouse, which means they cannot be made to give evidence against their spouse in a criminal trial. When civil partnerships were created, Section 80 of PACE was amended to make clear that civil partners are also not compellable against one another. A similar change was obviously not made to marital coercion. Moving beyond legally recognised relationships, it must be noted that nowadays in England and Wales, many couples choose not to get married and instead cohabit. It might be wondered why, if wives can be coerced into committing crime by their husbands, one member of a cohabiting couple cannot be coerced into committing crime by the other. And if we go further than that, it's not clear why, if wives can be coerced into committing crime by their husbands, children cannot be coerced into committing crime by their parents, and so it goes on. Now, because the defence of marital coercion is so very obviously discriminatory, it does raise concerns with the European Convention on Human Rights. And this is because the rights protected under the Convention must be protected in a way that is not discriminatory. One of the rights that everybody has under the European Convention is the right to liberty, which is protected by Article 5. Now, because they do not have access to the defence of marital coercion, the groups I just mentioned, so husbands, civil partners and children, could be deprived of their liberty simply on the basis of their gender or their marital status. That looks very worrying indeed. So what could be done to cure these defects of marital coercion? Well, the first option would be to reform the defence. This could be done by allowing all of the groups I've just discussed to make use of the defence, so husbands, civil partners, etc. I think the problem, though, would be redefining Section 47 of the 1925 Act so that it would draw clear lines. For example, I've already mentioned that cohabiting couples presumably are just as deserving of having this defence as wives are. How would we draw the line between when a cohabiting relationship is sufficiently long enough, for example, to give rise to a defence? I don't think there's any way to draw that kind of line without doing it arbitrarily. And of course, sometimes the law must draw lines in just that manner. If we think about the age of criminal responsibility, which is 10 in England and Wales, for example, the law just needs to draw a line. But when we're dealing with something about emotional pressure arising from relationships, I think that it's just far too difficult to draw lines in a way that is helpful, and so we might wonder whether one should be drawn at all. Given the problems with drawing principled lines around the defence of marital coercion, I think that a better solution would be to abolish the defence. Indeed, the Law Commission recommended such a change in 1977. The Law Commission felt that the defence looked like a relic of the past then, and I've said already that things look even worse now. So what would happen if we were to abolish the defence of marital coercion? Well, a wife who is arguing that her husband coerced her into committing a crime would have to rely on the defence of duress. That is what husbands, civil partners, etc. would have to do at present. Duress is much harder to establish than marital coercion. Firstly, there must be a threat of death or serious injury directed towards the wife, her immediate family, or someone for whom she could reasonably regard herself as being responsible. That obviously narrows down the threats that the wife would be able to argue forced her into breaking the law. Additionally, it must be shown that the sober person of reasonable firmness would also have broken the law in those circumstances. That obviously adds an objective element to the defence, which is not present in marital coercion. So what would the consequences of abolition be? Some people, including Vicky Pryce's solicitor, have argued that duress would be too narrow a defence for wives to use if they were in abusive relationships. Now, obviously, the criminal justice system should avoid re-victimising people if possible. But that does still not answer the fact that marital coercion is a discriminatory defence. Yes, many of the people, statistically, who are subjected to abusive relationships are women, but not all of these women are going to be married. Furthermore, it cannot be said that only women can be subject to abuse in relationships. So I think that rather than having a defence made specifically for wives, it would be far better for the law to put more resources into detecting and dealing with abuse in relationships in a better manner. One way of doing this would be to consider the question of abuse at the prosecutorial stage. It must be asked, for example, whether it is really in the public interest to prosecute someone who has been in an abusive relationship and has been made by their abuser to break the law. Additionally, even if duress is not made out, psychological pressure on the defendant could be taken into account at sentencing. So although I am in favour of abolishing the defence of marital coercion, I do not think that means that the criminal justice system should not take account of the circumstances surrounding crime at all.